I am pleased to welcome you to our first inaugural Judge Grady Teachers Institute virtual this year. I'm not going to take too much time to get started introducing our speakers for later this morning, but to do our formal welcome this morning, we are joined by Judge Gabriel Fuentes, who is a magistrate judge in the Northern District of Illinois Court. Prior to joining the court, Judge Fuentes was a pro bono chair at the law firm of General Block here in Chicago, and he also spent time as the assistant U.S. attorney in Chicago. Judge Fuentes has a JD from Northwestern. Prior to joining law school, he worked as a journalist and wrote for publications such as the LA Times and the Chicago Tribune. Judge Fuentes also has his BS in journalism from the Medill School of Journalism, also at Northwestern. And most related to our program here today, he served as a law clerk for Judge John F. Grady. Judge Fuentes, thank you for taking time to welcome us today.
Thank you, and it's really a great honor to be asked to participate today. I want to also welcome everybody to our inaugural session of the Judge Grady Teachers Institute, which really began as a tribute to our beloved Judge Grady. He passed away in December of 2019. He had 39 years of federal judicial service, and I'll talk a little bit more about him. But just want to really know how great it is that all of you are participating in this program. This institute named for him is something I think that's in many ways more than just a tribute to him. It's a really groundbreaking type of program that he'd be very proud of, helping to give teachers more tools to impart constitutional values to their students and to embrace and engage with those values, such as the First Amendment issues that you'll all be discussing today. And so I think Judge Grady, if he were here, would tell you that there's no more important a time for you to do this and for us to do this than now, to reconnect to our core values, values which we have needed and continue to need to help make our country a more perfect union, words that are drawn from the Constitution itself. Our founders understood that in order to continue to become a more perfect union, we would need to work at it. It would be a challenge. And I'm just more pleased than anything that the court is doing this and that you are participating, and we're all going to be members of one team in making our country a more perfect union. There are many people to thank for getting the program off the ground. I know I couldn't thank all of them in the time that I have, but I'll mention some. Bob Zaidman and Dave Bohan, who are attorneys and former Judge Grady law clerks like me, really helped spearhead the fundraising effort to get this program started and to push it and get it done. The chief judge of our court, Rebecca Paulmeyer, incredible amount of support for this program, and I want to thank her. I want to thank the American Bar Association here in the person talk who just spoke to you. Tiffany Middleton is here from the ABA. The ABA's support was critical in getting the program off the ground. And then our curriculum coordinator and developer, Mary Ellen Daniels, who is a veteran teacher here with us from the Illinois Civics Hub. Thank you for helping get this inaugural session going as strong as it's going to be. And I couldn't fail to mention our court's public service administrator, Lauren Thiel, behind the scenes really from the very beginning, as she is in so many things here at the courthouse, critical in getting us started. So thank all of you and many others. So let's talk a little bit about Judge Grady, who he was, why have we done this tribute for him, what was important about him. Really, I think it's a subject that I could talk to you about for the next couple of hours. So I'm going to proceed to do that. Not really. I wish I could, but in the time I've got, I want to tell you how important teachers were to his development as a pivotal figure in this court, in this court's history. The judge has an interesting background. He's a native Illinoisan. His father passed away when Judge Grady was 2 years old. And Judge Grady was 15 years old by the time World War II began, or excuse me, by the time it ended. So he managed to not be pulled into that conflict. He decided that he wanted to be a Jesuit. His mother was raising him Catholic out of respect for his late father, even though she was not Catholic. But in any event, he went to a Jesuit school in Wisconsin, had exposure to the Jesuit teachers there. And he later told our Seventh Circuit executive, Collins Fitzpatrick, in a lengthy interview about that experience. He said that his memories were that it was a really tough place. It appeared that Judge Grady, as we all know, and those of us who knew him, had something that the Irish like to call the gift of gab. So he liked to talk. And he liked to talk during study halls too, but that was not tolerated at the school. And he remembers that the Jesuit brothers, in his words, were, quote, just waiting for me to do it. And they knew he would. And so he was constantly in hot water there. He winds up leaving the school, deciding that he doesn't really want to become a Jesuit after all. He went to another school. There was a priest at that school who told his mother, according to Judge Grady, the following: "You've got to get this kid out of here. He's not doing anything, and he's not going to get into college." Well, he winds up undergoing this transformation as a student. And if you read the Fitzpatrick interview, the Collins interview, it's hard to quite understand or think that he even understood what drove it. He went from somebody who, in his words, goofed off a lot, to someone who was a great student. He wound up going to really great schools, Lake Forest Academy, Northwestern University, and then later Northwestern University's law school. He winds up reading a book at some point by Clarence Darrow, the lawyer who had successfully saved Leopold and Loeb from the death penalty and was the counsel in the Scopes Monkey trial. He decided he wanted to become a criminal defense lawyer. And so teachers at those various different steps of the way, I think, he didn't say this expressly in the Fitzpatrick interview, but it's very clear that teachers played this amazing role in shaping who he was and kind of giving him some direction in his life. He spoke very, very lovingly and in a revering way about his mother. And his mother clearly was a very important figure for him. My father passed away only in 1998. His father died when he was 9 years old. So I think I've seen through him maybe a little bit of what Judge Grady's experience was. And I think my father and Judge Grady both had to really look inwards and hold it together and learn from the examples being set for them by these teachers who they were around all the time. And so I know you all understand as teachers what an important part you play in the social, emotional, intellectual development of your students. And that's why, again, I think Judge Grady would be so proud of this program. So let's talk a little bit more about what the result was for Judge Grady, okay? He becomes a prominent Illinois trial lawyer, tried many, many cases in a small firm in Waukegan. He later became a solo practitioner. In between, he was an assistant U.S. attorney in the early 1960s, late 1950s. He was the head of the criminal division. It was a small office at the time, not like today. And so he tried many cases, and he tried many of them on his own. Today, it's always two prosecutors trying every case at least. And so he developed a reputation as this very earnest, honest person cut in the mold of Abraham Lincoln. And at some point, he winds up on the radar screen of the then senior Republican senator in the state of Illinois at the time, which was 1974, 1975, Senator Percy. And that results in Judge Grady being asked, hey, would you like to compete for this position, being a federal district judge? And he gets appointed by President Ford. He then spends, as I said, 39 years on the federal bench. And there's so many things to talk about his service and what it meant and how important it was. But to try to give you at least a glimpse or a window into it, I'll mention one case that is dear to me. It's the case of Karen Ulane versus Eastern Airlines. Karen Ulane was a crack combat pilot in Vietnam. I said, Karen Ulane, a little strange to hear that a woman would be a crack combat pilot in Vietnam in the 1960s. That's because at that time, Karen Ulane was a man. She later flew for Eastern and got glowing reviews. Eastern loved her, her colleagues loved her, or I should say him, because at some point he becomes a woman. And Eastern then decided, once he came out as being a woman, that they were going to fire her. And they did that. She sued. She said, this is sex discrimination. And Judge Grady, after a trial, decided that her claim was a good claim and that she had been discriminated on the basis of sex. That's what the statute says, on the basis of sex. Grady took that statute literally to mean that had she been a man, she would not have been terminated. Yet, because she was a woman, she was terminated, and he found for her. He was reversed by the Court of Appeal. Many decisions, Justice Kavanaugh recently said, I think it was 30 decisions, it had come out against Judge Grady's position in the years since. Well, Justice Kavanaugh wrote that in a dissent from an opinion that came out a little over a year ago, in which the Supreme Court said, yes, transgender persons cannot be discriminated against under the employment laws, that it is discrimination on the basis of sex. And Judge Grady, so many years later, was vindicated. And he told many people throughout his career that he knew he was right. When he was right, that's all he cared about. He didn't care if courts were to reverse him. And so he really wanted to just do the right thing. And that's what he did in that case. And as I said, he was vindicated. So just a giant of a person, years ahead of his time, a giant of a judge who was made by many people, but including people like you. So thanks again. And if Judge Grady were here, I know he'd thank you as well. It's a great honor that you're here.
Thank you so much, Judge. I so appreciate your welcome and you giving us the story and the background on Judge Grady. And we are thrilled to be kicking off this program, which will be the first of many programs in his honor. So with that, I am going to turn things over to Mary Ellen Daniels, who for most of us needs no introduction, but she is the lead mentor for the Illinois Civics Hub here in Chicago area. And is going to serve as our curriculum consultant and guide throughout the next 2 days. Mary Ellen, go ahead and take it away.
Thank you so much. And thank you for those really wonderful comments, really setting the stage for what we're doing here together today. You know, inquiry really is at the center of what we, the people, need to be doing about the institutions of power, ideas about justice, representation, freedom, and liberty that we all wrestle with in our classrooms with our students to make this curriculum learning come alive. And we're going to start by really curating some questions for inquiry. I saw some of you in the chat box when you were introducing yourself and talking about the First Amendment, give voice to the thing that, you know, the First Amendment is something that kids are curious about, they have questions about, it really resonates with them. And so we're going to start our learning by grounding this in questions you have about the First Amendment and freedom of assembly. And hopefully this protocol that we go through together over the next 40 minutes or so will not only prepare us for the Q&A section that we're going to have with Dean Chemerinsky after a break, but also maybe give you a strategy that you can use with your students to engage their voices in creating questions for inquiry. Things that could be used almost as a formative assessment of students to know what they know, what understandings they're bringing in, what misunderstandings they're bringing into the classroom, and how we can best serve them. And really the importance of this, I think, is really highlighted in this quote by Albert Einstein, a pretty smart guy who really put a lot more focus on questions than answers. If you look at this quote, if I had an hour to solve a problem and my life depended on the solution, I would spend the first 55 minutes determining the proper question to ask. For once I know the proper question, I could solve the problem in less than 5 minutes. So again, the importance of us asking questions as we the people in order to make that more perfect union. That idea of the First Amendment allows us that freedom of speech to ask these challenging questions as well. So one of the really, this idea of questions, I think is probably represented in all of our learning standards, no matter where we're coming from. I see a lot of people from Illinois in the room, but I also saw some people from California and other places. And most of you are probably familiar with the C3 framework for college, career, and civic life. And that question should really drive inquiry design in our classrooms. And the way we want to identify our desired outcomes is really with these compelling and supporting questions that really frame learning with the why of learning, helping students see the importance of this content to make it more sticky for them and relevant to their lived experiences. And a new document that's in the field, if you're not familiar with it yet, I know the ABA has did a lot of reviewing of this document and contributed resources to it. But something that's new in the field is something called the Educating for American Democracy Roadmap. It's really a cross ideological effort created by over 300 scholars and educators from throughout the United States for excellence in history and civics education for all learners K through 12. And at the heart of this Educating for American Democracy roadmap as well is the idea of inquiry as the primary mode of learning. And just a quote that's from that pedagogy companion of the roadmap: while there are several approaches to inquiry-based learning, most share a focus on authentic real-world problems, a commitment to active learning and collaboration, and an expectation that content knowledge is acquired as students work towards answers and solutions, whether it's through a year-long project or a single lesson covering a discrete topic. So with this in mind, we're going to use inquiry around essential questions of how does the government balance individual right to assembly with public safety as we go throughout these 2 days together. So I just want to kind of take the temperature of the room right here, like I might with my students, and I'm going to ask you to use the chat box for this. I'm going to ask you, how comfortable are you in using inquiry as the primary mode of learning in your classroom? Now, this is a blob tree that I sometimes use with adult learners and students to kind of take the temperature of their comfort level of what's going on in the classroom. So I want you to pick a blob on this tree, write down the number, and then explain your choice in the chat. How comfortable are you in using student-generated questions and the student-centered inquiry as the primary mode of learning in your classroom? Go ahead and use that chat. Which number and why did you choose it? And actually, I might ask my friend Lauren from the federal courts, could you kind of give voice to some of the things we're seeing in the chat right now? How are people feeling about using inquiry? What numbers are they choosing and why? There we go. Yep.
Okay, sorry about that. So we have Cecilia saying that feels like she's a 9. She feels like she's always has a plan and starts to go with it, and eventually I end up kind of on a tightrope. We have an 8 because I really am feeling a lot more confident about using inquiry as a mode for instruction after a summer filled with great PD and resources. Looking forward to putting this knowledge into practice. I have another 9 from Jennifer. She says, I know there is value in allowing students to have their questions guiding learning, but sometimes I don't trust they'll ask the right questions. We just got a 15 that came in. She says, I'm very comfortable with using inquiry as the prime mode of learning. Time is always an issue.
Mm-hmm.
Let's see what else we have. We have a 7. I like to use inquiry. I feel comfortable, but I feel like there is a lot more climb higher in the tree that I could do.
Yeah, absolutely. I mean, so we have a range of emotions there. And number 15, I see you. I might be asking you for some support as we go through this here. But again, our students might be uncomfortable with this curricular shift as well. So it's really important to kind of check in with them throughout the process with tools like this that kind of help them express how they're feeling about this and how we can better support them in the inquiry we do in the classroom. So hopefully we'll get you to move up that tree a little bit and feel a little bit more secure by the end of our time together over the next couple of days. Thank you, Lauren, for giving voice to that. I appreciate it. Now, one of the tried and true tools that I have shared with teachers, from kindergarten teachers to college professors, to really make inquiry structured, but yet authentic to student voice, is something called the question formulation technique. And many of you might be familiar with this, but we're going to iterate it and experience it today so that maybe it can deepen your understanding, and maybe I'll give you a few more tools, even if you use the QFT, to make it more successful in your classroom. For those that don't know what the QFT is, the question formulation technique is a simple but rigorous step-by-step process that's designed by the Right Question Institute to help students produce, improve, and strategize on how to use their questions in inquiry. And it allows students to practice 3 thinking abilities in one process: divergent, convergent, and metacognitive thinking. So we're going to experience this together today. Now, the question formulation technique always starts with something like a Q focus. The Q focus is what gets kids to ask questions. It's a question prompt. It could be a picture, it could be a quote, it could be a newspaper headline, it could be a political cartoon, it could be a movie poster. It really could be a lot of different things. But for us, it makes sense that it's the First Amendment. So what I want you to do right now is I want you to read the First Amendment here, and I want to give you individual think time to think about 2 or 3 questions you have about the bolded portion of the First Amendment above. Once you have those 2 questions, I want you to open up the Google Doc that I just shared with you in the chat box. So all of you go ahead and open up that Google Doc that's in the chat box. And I want you, on this open Google Doc, to write down your 2 or 3 questions that come to front of mind about that portion of the First Amendment. So Anonymous Otter is typing right now on my screen. You can just go below whoever's keyboarding in and start another bullet point and put your 2 or 3 questions in about that portion of the First Amendment. We're going to have a few more minutes for you to put those questions on this Google Doc. 2 or 3 questions. If you have more than that and you want to add more than that, follow your bliss and put more than that. But let's just come up with 2 or 3 to start with. Now, I have to tell you, as people are finishing up their questions, I think part of the secret sauce of the question formulation technique working is giving that individual think time for students to come up with questions before they share those questions with a larger group. Some students are introverts. They just need that time to come up with questions before they share it with a larger group. There are also some question starters that I'll share with you later, something like called a Q matrix that you could give to students to help them form questions of differing levels. But again, that individual think time, those moments of silence that we might be uncomfortable with, are really necessary for inquiry to work. A lot of times we think about inquiry as being deliberation and voice, but sometimes it's thoughtful silence for us to gather our thoughts to this end. All right, so let's go back to our protocol. Keep this document open because we're going to come back to it in a minute. All right, here. So the next thing that we're going to do with our questions is we're going to sort of categorize them as being open or closed. Now, open questions, there's no correct answer. There's multiple perspectives. They lead to deliberation and discussion. Questions that have things like why, what, and how tend to be open. Closed questions have agreed upon answers that lead to specific knowledge and understanding, like when, where, who is, can. They tend to be closed. What I want to do is go back to our Google Doc now, and I want you to put next to the questions you wrote down an O if that question is an open question, and a C if that question is a closed question. So let's go back to our Google Doc. and go ahead and categorize those questions as being either open or closed. So just as we did on the top here, this first person, they put a C next to it, they said it's closed. So go through and for the questions you wrote down, put an O or a C next to them for as being open or closed. O tends to be, there's no really right answer. It's deliberate, you know, we could deliberate it. Closed is there is probably right answers here. And I like what I'm seeing here on the second question from Anonymous Giraffe on my screen, but could be open. Sometimes the students wrestle with this as they're categorizing the questions in small groups. They might say, Ms. Daniels, I'm not sure. If we answer it this way, it's open. If we answer it this way, it's closed. I let them go ahead and put an OC next to it. Not because I like the television show, I thought it was subpar, but OC like, hey, it depends on the interpretation. Let's wrestle with that a little bit. The point of this is for the kids to wrestle with the types of questions they're creating. All right, the next part of the process is we are now going to do a little bit of rewriting of questions. You know, if we have a lot of open questions, maybe we want to create a few more closed questions to create some background knowledge, foundational knowledge. Vice versa, if we have tons of closed questions, maybe we won't challenge kids to open them up to make them more open. So why don't we do this as a group, and we can unmute ourselves to do this, is let's as a group choose one closed question and rewrite it so that it's open. And we will just rewrite that in a different color below that question on the Google Doc. And then let's choose one open question and rewrite it so it's closed, just to kind of get a sense of what that might feel like. So anyone want to unmute themselves and pick out a closed question that they think is a candidate for rewriting so that it's open? Go ahead and unmute yourself and tell us what you're thinking. Okay, I'm seeing one down here. Are governments bound to certain timelines to approve or deny permits for peaceful assembly? We're rewriting that to say, should governments be bound by certain timelines to approve or deny permits for peaceful assembly? Great. All right, let's choose one open question and see if we can rewrite it so that it's closed. Can we do that? All right, so I'm seeing down here, what is the legal definition for assembly? Yeah, we're making that closed. Now, a lot of times students get the message that open questions good, closed questions are bad. That's not the case. Closed questions are useful for that foundational understanding. Sometimes we just need to know the right answer. You know, if we're in our classroom and the fire alarm goes off, I don't want to discuss it with you. I want to know where to go. I want a closed response. Likewise, open questions are important for research and deliberation. So this really kind of stretches the kids to think about the different types of questions and what type of question is suited for the purpose that we're looking for. Now, in about 20 minutes, you guys are going to have time to ask one of the most prominent legal scholars in the United States, Dean Erwin Chemerinsky, questions. Let's get prepared for that activity by looking at our QFT questions here. And what I'd like to do is, I would like you guys to think about what are the three questions, and we're going to iterate this because we have a smaller group with us at the start today than we thought originally, is I would like us to kind of go through, and what I'm going to ask you to do is I'm going to ask you to put a plus next to the three questions you most want Dean Chemerinsky to answer at 10 o'clock today. So put a plus, each of you has 3 votes, put a plus next to the 3 questions you most want to ask Dean Chemerinsky. And maybe if you're wrestling with a couple of questions and you're like, well, I think if I combine these 2, I can make them one question for him to answer, go ahead and do that. Create an additional question that maybe combines a couple of points together to get him to answer that, you know, all that you want him to. So go ahead and actually put a plus. Let's vote on the 3 questions we most want Dean Chemerinsky to answer for us at 10 o'clock today. All right, Kathy. If we could, I think we're still at about, let's see here, 15 participants or so. So could we put our participants into 2 different breakout rooms? We could just make it random breakout rooms.
Yep.
And then let's have each of the 2 breakout rooms discuss with one another this question brainstorm, the questions that have been, plussed and such, and see if each breakout room can maybe come up with their 3 priority questions that they can reach a consensus on that they most want Dean Chemerinsky to answer.
Okay.
In these breakout rooms, what I want you to do is when you as a breakout room come to a consensus on the 3 questions you most want the dean to answer, go ahead and highlight your choices in yellow, okay, for your breakout room. And again, as a breakout room, you can edit the questions to combine ideas, or you can add more questions if you want to. So now that everyone has voted, let's have a little bit of a deliberation as to what are the most pressing questions that we want the answer. Does anyone have any questions about what your task is in your breakout rooms? And by the way, when you go into your breakout rooms, say hi, brief introduction. This is how you say my first name correctly, right? Like get to know each other a little bit and then discuss these questions and give some voice as to why they're important. And we'll come back in about 10 minutes to hear what you folks come up with, okay?
All right.
Are we sending them away?
Yes.
All right. Perfect. And let's just hear a little bit from each of the groups about what are some of the priority questions that you designated that you really want the dean to address. So from group 1, could a few of you kind of talk about what are sort of the priority questions you came up with?
The first question was, can the government limit the number of people based on a health concern? And John was talking about how Lollapalooza is coming to Chicago soon and people are not going to be wearing masks. So what happens with that? And then we talked a little bit about how the court already spoke to that a little bit with religious ceremonies, but if it's not religious, like what would happen? And then the second question, Jennifer is going to make it sound really beautiful when we're talking to the dean, but we were talking about like association and assembly and like where does conspiracy actually start when you're just somewhere listening and then there are actual illegal activities that take place, like where is that line drawn? And then the third one, we were just talking about Zoom, like right now is this assembly association, what do we do? And we kind of stole that from one of the questions down below. Those are ours. And I have a couple more that, if there's time, I would love him to talk more about based on the talk that we all listened to. That's it.
Yeah, absolutely. And by the way, I didn't do this activity to put you in a box as to what questions you're allowed to ask him, but just to kind of bring you through a protocol. Like a lot of times I would bring guest speakers into my class and they'd do their spiel and then it'd be like, does anyone have a question? And it would be crickets, right? So like activities like this where we can wrestle with what are the questions we really do want to ask? I think it's just really helpful to help students prepare. The person from the second room, I guess it was called room 10, because you guys are a 10. What did you guys have to say? What were the questions you came up with?
We had discussed a couple that we highlighted, and the one that I focused on was who or what gets to determine the limits of the First Amendment? How do we hold them accountable? I thought that, especially since it's a small group, it was a great opportunity to ask Dean Chemerinsky like a more pointed question, since he has so many YouTube videos and Barbri sessions on sort of the fundamentals of First Amendment scholarship that it's kind of a neat opportunity to ask him something more down to earth kind of, I guess, or something that high school students might be more readily able to digest, like, okay, so the Supreme Court has these rules that they establish, but what if we don't like those rules? Or, what if we find those rules not in line with our morals or something like that. How do we change things, or how do we, or should the Supreme Court be changing them, if based on political ideologies or things like that. Maybe I'm sure he has some great insight on those points.
Fantastic. Thank you. Well, in just a minute, we're just going to take, I think, a short break right here before we're going to meet with Dean Chemerinsky. And then maybe after that meeting, Kathy will give me just a couple of minutes to maybe process the QFT before we go into the next session. But again, the purpose of this activity is, one, for us to kind of collaborate with one another. And what are we wrestling with when it comes to this topic of the First Amendment and freedom of assembly and association? And also, two, to kind of start the discussion of what do we really want to ask Dean Chemerinsky, because we have this unique opportunity with him. You might want to keep this Google page open, and maybe harvest some questions there for the the question and answer session. But also feel free to go rogue. And if another question comes up, based on what he says, feel free to ask that as well. So Kathy, you want to give us direction about when we're all to be back here?
Yeah, so we are supposed to do about a 10-minute break. Dean Chemerinsky is going to join us at 10 after the hour, I hope, assuming technology decides to be my friend for once this morning. And so you are welcome to step away, cameras off, mute yourself, that sort of thing, get some water, take a break, and then we will come back.
Perfect. All right, and we can pause the recording, I think.
Yeah, thank you, I will. As we come back from break, we can see that our guest has joined us, Dean Erwin Chemerinsky from Berkeley Law. We are thrilled to have you join our teachers for the first inaugural Judge John Grady Teachers Institute. As I mentioned, all of our teachers previously have watched your wonderful pre-recorded remarks detailing the First Amendment and helping us to think about the rights of assembly and association. I know our teachers have some great questions for you, some really thoughtful follow-ups to your remarks, and as they think through how to apply this in the classroom. So I don't want to take too much time doing your introduction, but I wanted to allow you the chance to offer some remarks before we jump into what the teachers have to ask you.
Thank you so much for inviting me. I'm delighted to have gotten to do the video and just thrilled to have a chance for some interaction like this. I'm glad for you to ask me anything you want.
All right, Erin, I'm going to call on you first because I know you had some questions prepped.
Oh, no. Well, do you want me to ask the group questions or do you want me to ask my own questions?
Why don't we start with one of the group questions?
Great,
And then you
I think
can go
that's
into
a good
your
idea.
own question.
Okay. So our first question from our group this morning is, can the government limit the number of people who can assemble when there is a health concern? And our example was one of our group members was talking about Lollapalooza coming up in Chicago, and it'll be an outdoor event with many, many people who will not be wearing masks.
I think the answer to that is yes. First, it has to be done in a content neutral way that would apply to all gatherings above a certain size, not targeting, say, no more than this of Republicans or no more than this of Democrats. If it were content-based in any way, I think it would be unconstitutional. Second, assuming it's content neutral, then the test is it has to be substantially related to an important government purpose. What's often referred to in the law as intermediate scrutiny. I think protecting public health in the context of a pandemic would be regarded as an important purpose. And I think limiting the number of people would be substantially related to it. Certainly there's a significant part of the population that's not vaccinated, but there's also even a risk to those who are vaccinated. So my answer would be yes. Now, it has to be reasonable. If a court would say, no, that's too great a restraint. You're not going to allow more than 5 people at a time. It would take more of a justification. But so long as it's reasonable, it's allowed. In last year, when governors imposed restrictions on assembly, there weren't a lot of constitutional challenges, but there were some, and all of the orders were upheld, even when people who wanted to assemble brought challenges. So some of the governor's orders last summer were doing exactly this, limiting the number of people who could gather, and there were some court challenges, and in all of those court challenges, the government won.
May I ask a follow-up to Aaron's question?
Sure.
Dean Chemerinsky, masks are on their way to becoming political statements if they're not already there. And I'm wondering if you're aware of any case law or legal history in which a group has taken what might be, for example, a health measure such as a mask and tried to turn it into a method of political expression and therefore bootstrap themselves into a constitutional challenge. For example, at Lollapalooza, you cannot make me wear a mask because I want to express myself politically by not wearing a mask, because a political expression that I want to make is that masks are oppressive. They are a sign that I'm a Democrat or a Republican.
Sure. The legal test for that would come from a case called United States versus O'Brien, 1969. It involved a federal law that prohibited burning a draft card as a form of political expression. And the Supreme Court said, when we're dealing with conduct that communicates a message, the government can regulate conduct if it is an important interest unrelated to suppression of the message, and if the impact on communication is no greater than necessary to achieve the government's purpose. So that's the question. Is requiring wearing a mask an interest unrelated to suppression of the message? And is the impact no greater than necessary to achieve the government's purpose? My answer to that is the government's likely to win. As recently as this morning, I got an email from a student who's threatening to sue me over our mask mandate within law school, to which I said, go ahead and sue me. I have no doubt that we are likely to prevail on that, because our interest is in protecting health. It has nothing to do with suppressing a political message. And there really isn't another way to achieve what masks do. And so I think that the challenge of the mask mandates are very likely to fail under the O'Brien test. I saw a question briefly, I wasn't well in the chat, about gathering in churches. Actually, that's a different issue. And let me explain why. And that's because the Supreme Court's been particularly protective of gathering for religious worship. There have been 4 Supreme Court rulings that are notable over the last year. And they came out different ways as the composition of the Supreme Court shifted. The first of these was in May 2020, South Bay Pentecostal Church versus Newsom. Governor Gavin Newsom of California, as part of his closure orders, said that there could not be more than 25% of usual capacity at a place of religious worship and no more than 100 people. And a church in Southern California saw an injunction saying it violated free access religion. The district court ruled against it, the Ninth Circuit ruled against it, and the Supreme Court ruled against it. The Supreme Court was 5-4, with Roberts, Ginsburg, Brierson, and Kagan being the majority. Then in July 2020, there was Calvary Chapel, Dayton Valley versus Sisolak. It involved the governor of Nevada, who had imposed restrictions, including on gathering for religious worship. The church in Nevada brought a challenge to this. It sought an injunction. It lost in the district court. It lost in the Court of Appeals, and it lost in the Supreme Court. It was 5-4, 5 in majority, Roberts, Ginsburg, Brierson, and Kagan. Justice Alito wrote the dissent, joined by Thomas, Gorsuch, and Kavanaugh. But then in November of 2020, there was Catholic Archdiocese of Brooklyn versus Cuomo, came down the night before Thanksgiving, November 25th. And it involved the governor of New York limiting the number of people who could gather for religious worship. And it depended on how prevalent COVID was in the area, In the red zone, no more than 10 people could gather for religious worship. In the orange zone, no more than 25 people, and so on. And some Catholic churches and some Orthodox Jewish synagogues in Brooklyn brought a challenge to this. They lost in the district court, they lost in the Court of Appeals, but they won in the Supreme Court 5-4. And the 5 in the majority were Thomas, Alito, Gorsuch, Kavanaugh, and Barrett. Then in April of 2021, there was Tandon versus Newsom. Part of Governor Newsom's closure order said there could not be more than 3 households of people gathered in any home at the same point in time. It didn't distinguish why people were gathered. It couldn't be gathering more than that number of people for secular reasons, to watch the Super Bowl, or religious reasons, to pray. The district court denied the injunction, the Court of Appeals denied the injunction, but the Supreme Court 5-4 granted the injunction. The 5 in the majority again were Thomas, Alito, Gorsuch, Kavanaugh, and Barrett. 4 dissenters, Roberts, Breyer, Sinner, and Kagan. The Supreme Court stressed that religion must be treated the same as all comparable secular activities. If any secular activities like bike shops can open, then religious worship has to open. So to this point, the court's been much more protective of gatherings for religious worship than other forms of gatherings, but none have involved large gatherings in public places. That's not what these cases have been involved.
So how do changing technologies affect these First Amendment rights? Specifically, is meeting on Zoom, assembly, is it association? How do you think the court's going to handle that?
It's a great question. I think that meeting over Zoom or other electronic media is a form of assembly. Assembly doesn't have to be physical bodies together. And certainly assembling over Zoom is association. We are all associating today by being this meeting together. I think if the government were to attempt to regulate meetings over Zoom, I think that that would be susceptible to challenges based on freedom of association. I think the question that is implied here is, what if the regulation comes not from the government, but from Zoom or Twitter or Facebook? They're all private entities. They're not state actors. They don't have to comply with the Constitution. I know that President Trump recently sued Facebook and Twitter and Google for violating his First Amendment rights by taking him down. That suit is frivolous under current law. There is no basis for saying that Facebook or Twitter or Zoom has to comply with the First Amendment. They're private entities. An incident occurred at the University of California where Facebook refused to allow a speaker, Zoom refused to allow a speaker, believing that that speaker was identified as a terrorist and they didn't want to be responsible for material support for terrorist activity. Zoom can make that choice. It doesn't have to comply with the First Amendment.
May I follow up on that then? If Zoom is an assembly, what about group chats? Such as a group chat that can occur on Instagram or Snapchat or any of the other ways in which we can communicate in live interaction, aside from seeing each other's faces on video. Would those also be assembly?
I would say yes. Obviously, we're getting into areas where courts haven't yet ruled, but I don't think pictures being or video being present is essential for assembly. Let's take a telephone conference call. Wouldn't that be a form of assembly as well? And likewise, isn't group chat a form of assembly? The law will have to catch up with this, but remember, it'll only come up in a context where the government tries to regulate or punish for being part of that association.
But I think isn't what we're going to run into the private entity saying we're just following government regulation by putting this restriction into place, and that's where your challenge might come from?
But you'd have to challenge the government for that. You
Yeah.
can't challenge the private entity, Zoom or Facebook or Twitter. So if Zoom says we're not going to allow this speaker because we don't want to be potentially liable for material support for a terrorist organization, you'd have to challenge the government in its classification. Zoom can choose who to carry. Facebook and Twitter can choose what to put up if they want. Now, if they're doing it because of a government regulation, it's the government you have to challenge. I see a question in the chat. If private companies like Zoom and Facebook discriminate against groups assembling the platforms, does the 14th Amendment apply? No, for the same reason the First Amendment doesn't apply. The Constitution, whether it's the First Amendment or the 14th Amendment, applies only to the government. Private conduct doesn't have to comply with the Constitution. Before I came to the University of California, I was a professor at Duke Law School in North Carolina. Duke is a private university. If I were to give a speech criticizing the president of the university while I was there, I guess, again, if I would have criticized the president of the university, and he would have ordered me fired, I couldn't sue him or the university. The First Amendment doesn't apply. But now I'm at the University of California, and if I criticized the president and he fired me, I could sue. In fact, you're my witnesses. I would sue, since this is a public university. Well, my favorite example, which certainly can relate to your students, is a true story that I had of a conversation I had with my children 29 years ago when they were 9 and 6, and we were in a grocery store together. Diet Coke was giving away free baseball cards. 3 were pictured on the outside of the package. As went up and down the aisles of the grocery store, my 2 kids who were 9 and 6 were fighting, as they often did at that age. It was about who was going to get the extra baseball card. Finally, I said, be quiet. I don't want to hear anything else about baseball cards to leave the grocery store. My then 9-year-old turned to me and said, you can't tell me to be quiet. I've got freedom of speech. Well, I was ready for him. I said, freedom of speech means the government can't tell you to be quiet. I'm not the government, so I can. To which he, without missing a beat, turned to me and said, well, you're like the government to me. You shouldn't be able to tell me to be quiet. It's when I first knew that someday he was going to go to law school, and he's now a federal prosecutor in Los Angeles. But in answer to the specific question, if a private company discriminates, say on the basis of race or sex in employment, it violates a federal statute, Title VII of the 1964 Civil Rights Act, but it doesn't violate the Constitution. The Constitution applies just to the government.
Dean, one of the things as I was preparing some of the case studies for this session and looking at the cases we're going to be studying later throughout the week, how important is the distinction between the various aspects of the First Amendment, association, assembly, speech? Is there really a difference effectively or in reality? And if there is it important to the court or to us as individuals?
I think there's a very important distinction between the religion clauses and the expression clauses. And the courts always treated the religion clauses as having their own separate rules. And that's why I was clear that the cases about free access to religion have really just been about free access to religion. Now, I'm going to set aside why should we have more protection for religious conscience than for conscience based on secular beliefs, and doesn't run afoul of the Establishment Clause if we give people exception to laws for their religious beliefs, but not for their secular beliefs. If we give a religious exception to a vaccination mandate, but not somebody who has a secular objection, aren't we favoring religion? And doesn't that violate the Establishment Clause? But let me put that aside for a moment and answer your question directly. The court has not carefully separated the expression clauses of the First Amendment. So assembly has occasionally come up as something explicitly mentioned by the court. But as I said in my remarks, to a large extent, assembly has simply been subsumed under the protection of freedom of speech. Freedom of the press. There are some cases that specifically deal with freedom of the press, but for the most part, press freedom has been treated under freedom of speech. Association is a bit different. Now, to start with, association isn't mentioned in the First Amendment, but the Supreme Court has protected it as a fundamental right for over half a century. And for association, the court has created some very specific rules, ones that I mentioned in my remarks.
I was working on something and on the 1968 Democratic National Convention, and was learning about how the Mobilization Committee had applied for permits and had amendments to permits, and it kind of seemed like the city government was dragging its feet on giving an answer. And so my question is our government's, by that tactic, do they, kind of using a term that you had for association, do they chill assembly if permit acceptance or denial isn't done in a timely manner?
Yes, and there's cases about the need for prompt determination of license requests or denials for just the reasons you say. The Supreme Court has said that the government can require a license or a permit for speech so long as an important reason for licensing, so long as there's clear criteria that leave almost no discretion to the licensing authority, and so long as there's procedural safeguards like prompt termination of license requests or license denials. So just to break that down, there has to be an important reason for licensing. Classic example is the ability of the Federal Communication Commission to issue broadcast licenses. We don't want more than one person broadcasting over the same frequency at the same time, because then all you'll get is gibberish. So if you want to have a radio station or TV station, you got to have a broadcast license. Cities can have licenses, say, for the use of streets or parks to make sure that there's not more than one demonstration at a place at a time, or to make sure that it doesn't interfere with, we wouldn't want protests down the middle of Michigan Avenue or the Dan Ryan Expressway in rush hour. There have to be clear criteria that leave almost no discretion to the licensing authority. You know, it could be first come, first serve, or it could be the following specific criteria. But the concern is that the more discretion the licensing authority has, the more they could pick and choose based on the messages they like and dislike, and that would lead to content-based restrictions. And as you alluded to, there have to be procedural safeguards. There's to be prompt determination of license requests and judicial review of license denials. There's a question in the chat: how will the Freedom of Association protect, or will it, the Florida teachers being asked for political party association? I think very much it will protect the teachers in this. There's actually a Supreme Court case from the early 1960s, Shelton versus Tucker, where Louisiana required that teachers list all of the groups and associations that they're part of. And the Supreme Court declared that unconstitutional, saying the compulsory disclosure would violate their freedom of association. There was a Supreme Court case just on July 1st, which protects freedom of association. What was Alliance for Prosperity versus Banta is the name of the case. The Alliance for Prosperity Foundation versus Banta involved a California law that required that not-for-profits turn over to the state of California the form that they have to give to the federal government as to who their donors are. And the Supreme Court 6-3 declared that unconstitutional and said that such disclosure would chill association and therefore would have to meet what the court said, exacting scrutiny, and declared it unconstitutional. And the court was clear that it doesn't have to be proof that people are actually chilled, that the danger of chilling association is sufficient. the court cited approvingly to Shelton versus Tucker. So I think in light of that, requiring that teachers disclose their political party association will be found to violate the First Amendment, because it would certainly chill somebody from joining a political party in an area that's an unpopular political party.
It's not really a personal question, but Dean Chemerinsky, I think, I remember listening to your Barbary lecture after I graduated from law school and studying for the bar exam. And I didn't detect any progressive vision of the Constitution during your lecture of that in that particular lecture. Although I feel like you have been unjustly, I think, criticized for having a certain, viewpoint expressed. And I wonder if we're all educators here, and you're an educator, have been for many, many years. Can you tell us how you feel about what, because I struggle with that. I have a vision of constitutional law, and so do the Supreme Court justices, right? But as educators, we have a different mission and we have a different goal. And I don't want to inject my personal opinions into a conversation. I want to keep it an intellectual debate, and I want to point to facts, and I want to point to cases, but I have to choose which cases to point to, and I have to, could you just talk a little bit about that?
We all struggle with this as teachers. For me, the context and the setting matters enormously. When I'm lecturing to students getting ready for the bar exam, my goal is to provide them the information they need for the bar exam. It is totally non-political. My views don't matter. And I try very hard just to present the law in the most descriptive way and the way most helpful to students. I do a lot of lecturing to judges on recent Supreme Court cases. I try very hard to make that ideologically neutral. They're there to hear me tell them about what the case said and what it's likely to mean for them in their jobs. They're not there to hear my views. And I try to be neutral. I recently did a book manuscript for the ABA reviewing the past term of the Supreme Court. And I tried again, as best I could, to say, okay, this is what the court said and this is what the cases mean. I take the same approach to my classroom, where when I'm teaching, I'm trying very hard to have both sides come out. And if one side doesn't express by the students, I'll play the devil's advocates against my view and have that come out. A couple of caveats. There are places I don't try to be neutral. I'm not going to be neutral with regard to Dred Scott versus Sanford and issues of slavery, or Plessy versus Ferguson, or Korematsu, or for that matter, more recently, President Trump's travel ban. That there are places where I'll make no pretense of trying to be neutral. And I also recognize I'm not neutral, that the views that I have will come out in all sorts of ways, even if I try very hard to be neutral. The words I choose, the way that I characterize, the questions that I ask, I'm cognizant of that. So all I can do is try to be neutral. That said, I also have other forums where I do get to express my views. I write a lot of op-eds in newspapers, and they're just that, opinion pieces. I have a book coming out in August titled Presumed Guilty: How the Supreme Court Empowered the Police and Subverted Civil Rights. The title tells you what it's not neutral. So to me, so much depends on the context and the setting, what I'm trying to be.
Thank you so much.
I see a question. Do you think they will now challenge him to disclose their donors to the federal government? Absolutely. In fact, in this the chapter I wrote on this case for this book for the ABA, I talk about how everything that the majority opinion objected to about California requiring the disclosure would apply just as much to the federal government requiring disclosure. in the spirit of protecting the five freedoms and the values promoted in the preamble of the Constitution, when the court issues decisions which they don't necessarily embody the spirit of those values, what can be done in terms of reforming the court? Given that there have been several conversations about forcing justice to retire, packing the court, getting rid of life tenure, I hope that makes sense. It does, and obviously the topic of Supreme Court reform is getting a lot of attention now. President Biden has created a commission to look at reforming the Supreme Court. I'm skeptical that much is going to come from it, in part because the political realities make those reforms difficult. Think about increasing the size of the Supreme Court. That can be done by statute. The size of the Supreme Court is not set by the Constitution, it's set by federal law. Congress could, by law, increase the court. But we know that any legislative proposal to increase the size of the Supreme Court will be subjected to a filibuster in the Senate. There's no way the Republicans are going to agree to allow a Democratic president to expand the size of the Supreme Court. And there's no likelihood at this point that the filibuster is going to be changed. Or think about term limits for Supreme Court justices. There's bipartisan support for this. There are conservatives like Rick Perry who have argued for it, liberals like me who have argued for it. I would favor 18-year non-renewable terms, but I think it would take a constitutional amendment. And I don't see the constituency that cares enough to do the work that's necessary to get a constitutional amendment adopted. So I think it's great that we're talking about Supreme Court reform. I'm skeptical that we're going to see any major changes.
Dean, in the last couple of moments that we have you for this morning, I was wondering if you could maybe give us a little bit of a tease as to the cases coming up for this term and what the teachers may be thinking, what they may be teaching in the fall, and sort of a little bit of a trailer, a preview, if you will.
Sure, coming from the person who does the Supreme Court.
Yes.
Let me focus on three. Two have been granted and one is on the docket. The case that's going to get the most media attention is Dobbs versus Jackson's Women's Health Center. It involves a Mississippi law that prohibits abortions after the 15th week of pregnancy. Roe versus Wade, as you know, said states can't prohibit abortion before viability, the time which the fetus can survive outside the womb. That's generally thought to be the 23rd, 24th week of pregnancy. The issue flat out before the Supreme Court is that the states can prohibit pre-viability abortions. The state of Mississippi filed a brief in the Supreme Court urging it to overrule Roe versus Wade. And of course, if the Supreme Court allows the Mississippi law, then you have the laws like Texas, Ohio, Iowa, that prohibit abortion once the fetal heartbeat can be detected about the 6th week of pregnancy. And then you have other laws like Alabama's and a different Mississippi law that would prohibit all abortion. The composition of the Supreme Court has changed since its last abortion decisions. I think there are 5 justices, Thomas, Alito, Gorsuch, Kavanaugh, and Barrett, who would be inclined to overrule Roe effectively or explicitly, but that's it. New York Rifle and Pistol Association versus Carlette involves a New York law restricting having concealed weapons. It involves New York saying you can only have a concealed weapon with a permit, and the ability to get a permit is greatly restricted. The issue in this case is whether the Second Amendment protects the right to have guns outside the home and whether there's a right to have concealed weapons. Again, the composition of the court has changed, been more conservative. It's the last time the Supreme Court dealt with gun rights. Both of those cases, review has been granted. The briefs are being filed. They'll be argued in the fall. There is a case where a cert petition has been filed, but no action has been taken. And it involves the Harvard admissions program, the students for fair admission to Harvard versus Harvard University. And it's a challenge that's brought in part on the behalf of Asian American students. And it argues that Harvard's admissions plan, affirmative action, violates Title VI of the 1964 Civil Rights Act. Harvard's a private school, and as I said earlier, a private school doesn't have to comply with equal protection. But Title VI of the 1964 Civil Rights Act applies to recipients of federal funds. It says they can't discriminate on the basis of race. And the Supreme Court has said the standards under Title VI are the same as under equal protection. The district court ruled in favor of Harvard. The First Circuit agreed and ruled in favor of Harvard. And now the challengers are seeking Supreme Court review. The last Supreme Court case about affirmative action was in 2016, Fisher versus University of Texas, Austin. And in the majority there were Kennedy and Ginsburg, who are no longer on the court. Is there a link between conspiracy and felony murder? In one sense, yes, and they both sometimes get referred to as inchoate crimes because you're not punishing the crime itself. In conspiracy, you're punishing the plan to commit the crime. Felony murder, you're punishing somebody because they assisted, they didn't actually commit the murder. And so, yes, there is a link, but the legal tests are quite different. And I think that's because the First Amendment creates a limit on punishing somebody for conspiracy, whereas the First Amendment hasn't ever been thought to create a limit on felony murder. Obviously, both can be very troubling. I mean, if we punish conspiracy too broadly, then we're really punishing association. And if we punish felony murder too broadly, we're really punishing people for crimes they didn't commit. And obviously, if what you've done in the felony murder is be part of the planning, then it sounds to be like conspiracy, so there's the link there. But the important thing is with regard to conspiracy, what I said in the video, the Supreme Court has said somebody can be punished for conspiracy if they actively affiliate, knowing of the illegal objectives and with the specific intent to further those illegal objectives.
So Tracy Freeman is one of my regional civics instructional coaches in Illinois, and she has given me the moniker that I am a ZJ or a Zoom J, much like a DJ at a club, and that I like to work a chat box during a webinar. So I couldn't help myself, and I put in the chat some links to SCOTUS blogs about the 3 cases that Dean Chemerinsky highlighted if you wanted to do a little bit more research, and they have also links to the Supreme Court of the United States website, things of that nature. So I just wanted to highlight that. So that is in the chat. And before we move on, I just wanted to give a little bit more voice about, a little bit more recap about this question formulation technique method. And just hear a little bit from you all about how you might use that before we transition into our jigsaw groups. Now, the question formulation technique really is a simple and elegant protocol. Like I said, you can use with kindergartners, with scaffolding, to adult learners like yourselves to help people create, iterate, and use questions to guide inquiry. And there are basically several components to the question formulation technique. If you have not used it in your classroom, I have hyperlinked a step-by-step guide for you at the top of this slide deck that you have access to. If you want to try this with your own students, I would tell you that the first time you do a question formulation technique with your kids, it's probably going to take a class period to teach them the protocol. But once they know the QFT protocol, especially middle and high schoolers, you can do one of these in 15 to 20 minutes quite quickly. Now, the first part of a QFT is up to you and I, and that is coming up with a good Q focus. For us, it was the First Amendment of the Constitution. But again, if you're using this in a history class, it could be a quote. It could be a photograph. It could be a data point. And then you want to teach the students rules for producing questions. There are norms for the question formulation technique that, because we're adult learners, I didn't engage you in. But again, there are basically 4 simple and easy rules that the creators of this technique suggest that you employ in your classroom to make an equitable opportunity where all students feel safe and they can contribute questions. For example, ask as many questions as you can, quantity, not quality, to get all levels of questions on the table. When the kids are answering, coming up with questions, let's not stop to answer, judge, or discuss questions. Let's just put our questions on the table. If they're doing this in small groups and you have a secretary or a scribe, have them write down every question exactly as stated. Revisions will come later. I know nothing makes me feel more judged is when people start revising my thoughts in real time. So this sort of avoids that from happening. And then if someone makes a statement, the group can help them make that into a question. And then you're going to give them time to produce those questions. We did that on a common Google Doc, quietly, silently, but you could have students in small groups do that verbally, create those questions. Then you have them categorize those questions as open and closed, and perhaps change some questions depending on how you're going to use those questions coming forward. Then you're going to have students prioritize questions or make choices. Now, the way that the QFT is so powerful for you and I is that steps 1 and 5 are really where you and I guide the process to meet our learning targets, that we create questions that are useful to us. I kind of equate it to bumper bowling. Have you ever taken kids bowling? Those bumpers are pretty useful to get that ball to hit the pins. Likewise, if we just have a free-for-all and students generating questions, it may not necessarily meet the learning targets that we're intending. So depending on the Q focus you pick, that's going to guide the types of questions students come up with. If you pick the wrong Q focus or prompt, you're going to get the wrong kinds of questions. Likewise, at the end, how you have students prioritize questions brings power to this protocol. What if I asked you, what are the most interesting questions you think for your students? You probably would have picked different questions on that Google Doc that we all created together than the ones that you did. What if I asked you, which questions do you think are most answered in case law? You probably would have picked different questions than ones that you did. The purpose for our questions was to ask questions of Dean Chemerinsky. So we prioritize questions that way. So a lot of teachers fail with the QFT because they tell students, pick the best questions. Best for what? You have to give a purpose or an intention. Next steps. We had you use the questions to ask Dean Chemerinsky. So how are they going to use those questions? Is it with a guest speaker? Is it for a research project? Is it for a Socratic seminar? Is it for questions they're going to ask as lawyers in a moot court, or as judges in a moot court, or lawyers in a mock trial? Again, how are they going to use those questions? And then reflect on the process. We did this all very quickly, but again, if you go to the website, the Right Question Institute, they have videos and step-by-step guidance of how to do this, okay? So with that, we're gonna come back to these questions in a little bit later with your jigsaw groups and next week, but I'm actually gonna yield the floor now to Kathy for what we're gonna be doing next.
Thanks, Mary Ellen. So what we are going to do, I think I'm going to sort of do a little bit of stuff on the fly and let you all go from small groups since we are a small and mighty team. But if you go to the Google Drive for this session, there is a document called Case Summaries. And Mary Ellen just had on her screen, and we can bring it back up too. We've broken you into some pairs and some threes. There's 6 case studies total. So each group will be looking at 2 case studies. What we're going to ask you to do is read through the case summaries, and then there's some discussion questions for each of the case summaries. I'd love for you, if you want, you are welcome. We're going to put you into breakout rooms. You're welcome to stay in the breakout room with your partner or your threesome for the next half hour or so and read through your assigned case studies and start the discussion. You are also welcome to exchange emails and do this offline at a later date. We want you guys working collaboratively, but respecting, we all get very tired of sitting in the same space. So if you can read through your case studies, work with each other to answer the questions. When we come back next week, we'll do this as a jigsaw and have you shuffle out so that you have some opportunity to learn from one another. So that's thing number 1. Thing number 2 is that there is a second document in the Google Drive called In Between Session Readings. So there's 3 additional readings we would like you to look at before the next session, so we don't have to spend time in small groups doing some readings. The main one is a document annotation on the case that actually Dean Chemerinsky set us up perfectly for, which is a look at the Supreme Court case that was decided in July, dealing with the right of association as it deals with these disclosure issues. And I think they're really, Erin, you asked some great questions. I think Tracy, about how this may apply to some of the teachers, the laws we're seeing passed around teachers that may get into play in this fall. So we would ask you to do those two things before our next session. So one is work with your partner or your trio through the case summaries, feel confident about your case that you could report out to a different group. And then the second would be to do the in-between sessions reading.